Hello everyone, I'm going to work on the tutorial questions. W7H2 question 1. The primary issue of this question is whether the court should grant bail to Mabuto. And according to the request of the question, I will talk about both arguments could be used for Mabuto's bail in the first appearance and arguments in favor for the prosecutor for opposing the bail. Firstly, on behalf of Mabuto in favor of bail, what arguments should the defense side raise? Let's start from the constitutional rights. Mabuto's right to liberty and the presumption of innocence are protected by Article 5 of the Bill of Rights Audience and Article 28 of the Basic Law. It is for the prosecution to show that the bail of the accused should be denied or subject to conditions beyond a reasonable doubt. So basically, being granted a bail is a constitutional right for Mabuto. Further, let's move on to the statutory rights. It is a presumed right for Mabuto to be granted a court bail under Section 9G, subsection 1 CPO. Yet there are several key requirements for bail shall be fulfilled. Mabuto need to fulfill the abstracts of bail conditions subject to Section 9D, subsection 2 CPO and the case law HKSAR Yang Tai Kwong. Mabuto will now fail to surrender on the required date and will now commit an offense while on a bail and will not interfere with witnesses or obstruct the course of justice. For the facts support the grant of bail, we shall consider the following aspects of respectively. First is nature and the seriousness of the offense. Mabuto's assaulted students on the aeroplane. For this issue, the indecent assault charge is not that serious. Mabuto came to Hong Kong seeking asylum. Therefore, he will certainly be very cautious about his behaviors and conduct in Hong Kong in order to obtain the right of abode. Otherwise, he will face the risk to be expelled from the Hong Kong territory and be extradited back to his domestic country, facing with serious criminal charge. As a reasonable person, he will definitely understand his current situation and try his best to fulfill any conditions attached to his bail. Considering Mabuto's background and association, who is a long-time dictator of a small Central African country, his social status and association would be at a privileged level compared to normal persons, and accordingly his financial status would be guaranteed even for expensive payments for cash bail. And the age of Mabuto presumably is senior, since he has ruled a small Central African country for 20 years and 28 wives and over 100 children. Since for the senior person, the court shall present more tolerance, since there is barely any chance for them to commit any violent interference to obstacle judicial justice and abscond easily. According to the facts description, there is no history record that he had skipped bail or breached any bail conditions. So besides there is a student who is the victim as well as could be a witness for the indecent assault charge. For the other charges, there still need more real evidence and statements before a strong case can be established. For the torture charge particularly, since the crime has been committed by the secret police, it would be very difficult to adduce evidence against Mabuto or at least collecting material or sufficient evidence within a short period of time. Based on the above, these points do not cause any concerns that Mabuto will breach the objects of bail conditions. Furthermore, bail conditions can be imposed on Mabuto according to Section 9D, subsection 3, for the purpose of ensuring that Mabuto will fulfill the objects of bail subject to Section 9D, subsection 2, CPO. The conditions can include the cash bail, surrender travel documents, shall not leave Hong Kong, to report police station regularly, and stay at a specific location, not go to some places, and not contact with some people, etc. So it is for the prosecution to show that the bail of the accused should be denied or subject to conditions beyond a reasonable doubt. where if prosecution cannot prove beyond a reasonable doubt, the bail should be granted to Mobutu accordingly. Next, let's talk about on behalf of the prosecutor opposing the bill. What arguments should the prosecution raise to argue against the granting of bail to Mobutu? That's starting from the constitutional rights again. Although Mobutu has a right of liberty under BORO and the Basic Law, it is a qualified right, not an absolute right. And this right can be refused in the circumstances set out in the Section 9G CPO and the case law HKSAR Moses Mohammed. Furthermore, there are many reasons presenting to show that Mobutu will breach abstract of bail conditions. Since Mobutu is highly likely to fail to surrender to custody, as the court may appoint, which violates Section 9G subsection 2C, since Mobutu is a foreigner without intimate connection with Hong Kong. Additionally, he has 28 wives and over 100 children, which is a strong motivation for him to flee away for reunion with his family. Mobutu is also very highly likely to commit an offense or interfere with the witness or obstruct the course of justice while on bail, which violates Section 9G subsection 2F and A. Since he is a dictator over 20 years, he has been getting used to acting in his own way to solve his problems without considering other people's interests and rights, not mention judicial justice in domestic society. The likelihood that he would in person or utilize his powers and resources to interfere with judicial justice is very high. Mobutu has committed torture, which is a serious crime. Mobutu has a behavior of running away as evident when he absconded to Hong Kong after losing his political powers in his home country. And Mobutu used to frequently give his instructions to his secret police to torture opposition politicians and NGO staff. Thus, he is very likely to continue his crimes secretly again. Also, Mobutu has been overthrown as a president and fly to Hong Kong. This is definitely a huge blow to him, and he may very likely enter unstable mental status, and which may lead to further extreme or illegal conducts. Mobutu may have a violent tendency due to his dictatorship in a small Central African country for 20 years. In addition, he tortured his opposition politicians and NGO staff, and even assaulted students merely due to she failed to refer him as His Royal Highness when offering him a drink in the first-class section. So the students would be a witness for the indecent assault charge. For the other charges in his home country, the detail has not been provided in the fact description though, but all these crimes are very serious offenses. Furthermore, Mobutu should not be granted a bail as he has attained 18 years old and need protection by authority, since his personal safety might under threat from his opposition politicians, secret agents, or others who intended to murder him. Last but not the least, Mobutu should not be granted bail by magistrate, since he is under the charge of treason. According to Section 9G, subsection 10 CPO, the bail of this crime shall be admitted only upon the order of a judge. Having established the defendant's party's arguments are beyond reasonable doubt, court bail should not be granted to Mobutu thereafter. This is the end of section W7H2, question 1. For question 2 and 3, please take a look of my colleague's recording. Thanks for your time for watching this video.